if your business has a Twitter account or a Facebook page, you've got all kinds of content and logos and newsletter articles on there. These are all types of intellectual property. If you have video or audio that you create for your marketing or for your customers, this is intellectual property. Brochures, podcasts, I mean, there's just, I'm sure you can think of other types that you may use in your business. It's really endless, the types of intellectual property that are out there. So now I want to go through just a few simple steps that you can use once you identify your own intellectual property to try to establish some more protection for it. So trademarks are fundamentally brand names, slogans, and logos. Basically the things in your marketing materials that differentiate you from your competitors. And the most important thing to do with a brand name is to think about it first before you even adopt it. Now, obviously, sometimes that's already passed. We can't undo the past, but you may be always coming up with a new brand name. It may be a new website or a new blog or a new division of your company, and you've got a new brand name. The most important thing to do is think about it before you choose it, before you lock in on it. Do some searching. You can search for free at the U.S. Patent and Trademark Office. You can search the major search engines, and you can search a variety of sources online and consider alternative spellings and soundings to see if anybody else in your industry or a related industry is using it. If there's two totally unrelated businesses, they could likely coexist. One example of that is like Delta Airlines and Delta Faucets. Very different businesses. Nobody walking in the airport seeing a sign for Delta is like, oh, is that where we go to buy a new sink? You know, so they're not competing with each other. You really just have to worry about what's potentially competing with your business. Another way to enhance the protection of your trademark is to use it properly. So you use a TM or an SM, depending if you have a physical product or you have a service on the upper right-hand corner. Like you can see on my logo up here, I've got the R with a circle because it's registered with the U.S. government. Another way that you can use them to differentiate and really stand out in your marketing and enhance the protection is to use them in bold lettering or a different font or italics, so that even when it's in text or in your email signature line, it stands apart as, this is our brand, this is important to us, this is how we identify ourselves, and this is something that we're protecting and we care about. So those are trademarks. Copyrights is all the other types of content that we talked about. The websites, the photos, the articles, the newsletters, the audio or video. Copyright protection starts when the work is created and distributed. So if I publish a new article, post it on my website, I've got some protection just when it's put up there. It's done, it's available to the public. I can enhance that protection by putting a proper copyright notice on it. Proper way to do that is to use the copyright symbol, the year that the work was created, the owner of the work, and the phrase all rights reserved. So it would be copyright 2010 Eric M. Pellman Associates PLLC, all rights reserved, for example. Now if I were doing an audio podcast on my website, I would want to read that aloud at the beginning and or the end of it. If I'm doing a PowerPoint presentation, I want to put that up there. If I write an article, I want to make it clear that I own the copyright, or a video. So use it prominently. It tells people, hey, this is good content, this is content we care about, and this is content that's protected, so don't steal it. And if they do steal it, it's now a heck of a lot easier and cheaper to go after them. Other ways that copyrights can be protected is to register it with the Library of Congress. It's a fairly straightforward process. The filing fee is less than $50, and the forms are available online at the Library of Congress website. Another important way is in contracts for both protection of copyright and trademark. When you have contracts with business partners or with employees or even with vendors, they should have clauses that cover intellectual property. Who owns the material that's going into the relationship, and who owns the materials that could be created from the relationship? Is it going to be shared? Is it going to be owned by the party that's providing most of the funding? Is it going to be provided by the party that's providing most of the creativity? There's all sorts of ways that could be worked out, but if it's not in writing, it's a very scary proposition. One, to not know really who owns it, and two is, many people would be surprised to learn that without an agreement in writing, much of the content that's not generated by an employee, a full-time employee, is owned by the person who created it. So if you contract with somebody to write your newsletter, and they're not an employee and you don't have a written agreement, they actually could own that content, and they could republish it or sell it to somebody else, or anything like that. The third major type of intellectual property is patents. I don't do patents in my profession. They're a lot different from copyright and trademark. They're generally more complex and more expensive to obtain registration for and to enforce, but they cover machines and inventions and devices, even some business processes and computer software processes. And if this is something that's important to your business and is something that your business has created or is in the process of creating, I urge you to look at patent law and, most importantly, to speak to an attorney, because, like I said, it is complex and there are important deadlines which, if they're not met from the time that your invention is disclosed to the public and the filing date of the patent, if those deadlines are not met, you could lose all of your rights that come with a patent registration. And a patent registration is even stronger than a trademark registration or a copyright registration. That's why you read a lot about in the news patent disputes, Google, Microsoft, these companies with huge investments in technology, Apple over the touch screens on the iPhones and things like this. But it doesn't have to be such a huge investment. If it's something that's at the core of your business, then it certainly is worth looking into whether or not that's something that should be patented. So those are the three main types of intellectual property: trademarks, copyrights, and patents. Now, the benefit of isolating these and protecting these is really severalfold to your business. Okay, as we noted, it's easier and cheaper generally to go after copycats when it's protected properly. But just as important, in my opinion, as a small business owner myself, is that it really creates additional value for your business. It creates additional value to your customers by showing them, we've got great content, we've got great brands, and we care about protecting them. And this is something that we provide to our customers. And in addition, having a great and strong brand makes it easier for the customer to remember you, to refer you to a friend, to find your website when they need a phone number or an address. These are some of the many benefits of having strong, protected intellectual property.